Well, good morning, Miss Candace. I'll say good morning. How's everybody doing? Super. Lenny's here. He's just, he'll be in just a second. I can tell you there's a 99.9% chance he's going to ask you to turn your cameras on. So if you need to take a minute, do a little hair fluff or throw some lip gloss on, just so you know. I don't care what you look like, and he doesn't either. But yeah, just so you know, he'll want cameras on.
Okay.
Hey, Kate. Kate, it's so good to see her face again. Okay, I see Carrie, Melissa, Candace, and I have an iPhone. iPhone, can you tell me who you are? You're on mute. If you can't talk where you're at, if you can just type it in the chat box, that would be helpful. I can hear you. Who's on iPhone?
It's Trisha. I'm trying to figure out. I'm on my iPhone. I'm sorry. I'm trying to figure out where to do this.
That's okay. I just wanted to know who you were. I got you. So Trisha is iPhone.
Turn your cameras on, folks.
They're getting there. I already told them. Trish, how was Easter with that grandbaby?
Wonderful. I'm with him right now, getting his bottle ready because when he wakes up, he'll be screaming. So yes.
Candace is working.
We got to share the screen. We got.
That's okay, Candace. Take your time. Do what you got to do. You want this one?
Yep. We have to give kudos to Jerry because only one person wanted to come in and see me today.
I'd have been there, Lenny. I'm just taking care of my grandson, and he's a little more important to me than you, even though I love you tremendously.
Our conversation's over.
I love your honesty, Trish. I love it.
Hey, I want to share something with everyone while we're waiting. What is the longest, let me ask a question first. What is the longest you've ever worked with a client before you finally got them to closing?
Probably a year and a half.
I just closed on a deal that took me 3 years.
Wow.
And she deserves a medal for dealing with them and getting it to close in 3 years.
And you know what? Lori's taking over now.
Yeah, I get to sell their house now, so yay.
That's awesome. 3 years. 3 years.
Well, when I tell my clients that I don't give up, I didn't realize it'd be 3 years. Okay. I just didn't realize that.
All right, we're gonna get started. We need this. So we are going to go over the West Virginia residential contract, which for everybody to know, it is the new version of it. So there's changes to it.
Can everybody hear?
Yes.
Okay.
So in West Virginia, whenever you do the residential sales contract, you're also going to have to do the jurisdictional addendum. And the reason you're going to have to do jurisdictional addendum is because it says in the contract that it's part of the contract. You also must do the notice of agency. You'll have a notice of agency for listing agent signed by both buyer and seller in your contract, and for the buyer's agent signed by the buyer and the seller in the contract. We'll touch on those a little bit if we have time after going through the contract of sale. In West Virginia, it's not a good thing to have blanks in the contract of sale. So everybody knows how to get to their contract of sale in DocuSign, correct?
Yes.
Yes.
Camera's on, Robin. Okay. So the sales contract is made on and then the contract date. So you're going to put the date that you're writing the contract in that spot. And it's going to be between the purchasers and the sellers, whoever they may be. And who, among other things, hereby confirm and acknowledge by their initials and signatures herein that prior disclosure in this real estate transaction, whoever the listing company is, their company name will be there, represents the seller, and our name on the contract of sale will automatically be there if we are representing the buyer. It'll automatically clean for you. That is our name, Keller Williams Premier Realty. We would be the selling company. And then you're either going to have to put that the selling company represents either the purchaser or the seller, and that the listing company and selling company are collectively referred to as broker. If the brokerage firm is acting as dual representative for both the seller and the purchaser, then the appropriate disclosure form is attached to and made a part of this contract. In consideration of the mutual promises and covenants set forth below, and other good and valuable consideration, the receipt and sufficiency of which are acknowledged, the parties agree as follows. So that first paragraph lays out the foundation for the contract of sale. It's going to give who the representing companies are prospectively, the date that the contract is being offered, and who's representing who. It says that there are mutual promises and covenants set forth below. So if there's anything in here that a person may not understand, the best thing that you can do is have them seek competent legal advice, because this is a legally binding contract. Once initialed and signed by all parties, it is an agreement. And it tells you that in that paragraph. They want out of it, tell them to seek competent legal advice. You don't want to show up for closing, tell them to seek competent legal advice. Any questions with that paragraph?
No.
Nope. Got it.
Hey, Lori, you gotta turn your camera on. Oh, man.
Do you ever run into problems with the purchaser and seller box? I've run across it 3 times where even though you click it, when you go to get it signed, it's not coming back like that through DocuSign.
No.
Okay.
What did I just do with my DocuSign?
Click on Google down at the bottom with your picture.
Oh, there we go. Okay. So everybody can see the contract, right?
Yes.
Okay. Now I should be on. I was trying to switch from my phone to my laptop
Yeah, you are.
because I couldn't see it on my phone. So I was trying to get it hooked up on my laptop.
So the next paragraph goes into the real property, because you're selling real property. In West Virginia, can you sell a mobile home?
No, not if it's on a rented lot.
That's correct. You can sell a mobile home if it's on land, because you're selling the land, you're selling the real property. But if it's on a rented lot, that's a vehicle, you gotta stay away from it.
Yeah, it's got a title.
All right, so real property, you're gonna wanna fill in all this information. Now, West Virginia on new construction makes it very difficult to figure out this information. But you'll see a lot of times this will come across blank. It really shouldn't be blank. So you can go to the tax record in Bright, and it will be there. You can also go to the tax record of Berkeley County and look up the property. And it will be there. You want to fill as much of this information out as possible. Anybody have any questions on where you find it? So if you're going to find it through Bright, what you're going to do is you're going to go into Bright and you're going to do a search under the public records. And you're going to try and pull up the tax record of the property. If it's not there, then there's another website that you'll need to go to. And typically what I always do, because I can never remember the website, is I go to the Berkeley County Sheriff's tax record.
Okay, Lenny, am I wrong when I do this? Maybe I'm doing it the wrong way. I do it from Bright and I go up to the little icon above the pictures and says to public records.
Yeah, you can do it that way.
Okay, that's the way I've always done it. I didn't know there was
But
another way to do it.
it's not always going to be there, especially in West Virginia.
Okay.
Okay, you've just been lucky. Because especially with new construction, because the tax records run a year behind,
Gotcha.
and because you're always paying taxes in West Virginia in arrears, which is important for your buyer to know when you're doing the contract.
Yeah.
Because the tax bill is going to come in the seller's name.
The
Seller's
first year.
not responsible for that bill. You are the buyer. So they need to know that. Most settlement companies will tell them.
Mm-hmm.
So you want to fill in all that information that you possibly can. So that's the tax map, the legal description, which is not the tax ID number. what block and square, the section, if it's in a subdivision, how many parking spaces they may have, the county and the municipality. Now, West Virginia doesn't have municipality. However, if it's in Berkeley County and it's in Martinsburg, you can put Berkeley, Martinsburg, or Berkeley, Inwood, Berkeley, Jaredstown, okay? Deed book, library and folio. Then you're gonna put the street address. And then the city, state, zip code. Under the price and financing, you're gonna put a down payment. What's the down payment typically gonna be?
$500 to $1,000, depending on, down payment. It could be
Oh,
10%.
down, yeah, depending on the type of financing,
That's
3.5%, 20%.
That's correct. So they could be going VA or USDA, and they're not gonna be putting any down payment.
Anything.
They're gonna put zero.
Put a 0. Yeah.
So do not confuse the earnest money deposit with the down payment. I've seen people do that. If they're going to get a first trust, which most people are, then their financed amount is going to be here. You're going to get that from the lender. If they're getting a second trust, which they may get a second trust if they're using the West Virginia First Time Home Buyers Program. They do have one. I think they can qualify for, I think it's up to $7,000. However, I have yet to have anybody qualify. Because most people that qualify for that program actually don't qualify to purchase the home.
Wow. Okay.
But they do have one available. If it's somebody that's going USDA direct, they could possibly qualify. If the seller is going to hold any kind of a trust, that's where that would go. And it's going to be seller financing. So if the seller's doing the financing, that would go there. And then the total financed amount, and then your sales price. I don't know why 500 is there. This is supposed to be a blank one. Must have been an offer. I was writing that stuff. And then if they're going to ask for any seller's assistance, that would be put on the bottom line. Seller paid subsidy. That's what they're talking about. And then you're going to have to put down if they will obtain, assume, whether it's fixed or adjustable, and then the type of loan. And then these are going to be the appropriate addendum attached for the type of loan, which is USDA, VA, conventional, FHA, or if it's cash, or other. Other could be seller paid financing. If they're going to obtain a second deed of trust, you have to let them know. And if it's going to be an assumption, either obtain it, assume it, or fixed an adjustable rate, same thing. And then, of course, if it's an assumption. Now, this is something that's going to probably sneak back into our industry, is the assumption. The reason is right now there's a lot of people that have refinanced and they just like a streamline, either a VA or an FHA, and they refinance from a 5% interest rate down to like a 3% interest rate. And it's going to make it attractive for a buyer if the seller is willing to sell and allow somebody to assume that loan. So don't be surprised if you start seeing contracts, the interest rates going up, and suppose it, and the thought behind the interest rates going up is we are probably going to see a double-digit interest rate. then we're really gonna start seeing sellers that had these 3% and 5% interest rates that were locked in for 30 years, trying to sell their properties. They can't sell them because the person can't afford
Mhm.
unless they assume that person's loan.
Okay, Lenny, I have a question.
Okay,
So, because I've never done an assumption loan. So they're assuming the person's mortgage, but that value is going to be probably less than what their purchase is. So do they then take a second mortgage for the difference for the purchase price? How does that work?
that's a really good question for a lender.
Okay.
Now, and the reason I say that is because, as we all know, assumptions haven't been
Yeah.
the norm in this industry for a very, very long time. And guess what, Lori?
But
You and I are in the same boat. I've never done an assumption.
yeah, I've never done one, so I have no idea how that would work.
And they briefly touch on it in broker school.
Mhm.
This is what I can tell you about an assumption. The buyer is going to purchase the property for X amount of dollars. They're going to have to put down cash down payment. They're going to bring cash. That's probably going to pay the commissions and the taxes and all that good stuff. And then they're going to assume the loan. And then when they assume the loan, they have to discuss if they are going to, like if it's FHA, they have to be approved. VA, they also have to be approved. Okay. So I know in the VA instance, it doesn't have to be a veteran to assume that mortgage.
Mhm.
So the veteran takes a risk in allowing somebody to assume that mortgage because that mortgage is going to stay in the veteran's name until it's paid off. Now, my understanding of the assumptions are they do it to purchase the property. And usually within a year to 2 years later, they will refinance the property in their own name and pay that off.
Can we have a lender come and talk to us about all this?
Yes, when we should, because I think it's something that's going to happen. I went on a listing appointment last night. The guy has 3.25% interest rate. He wants to sell his house. He wants to turn his money back into another property. And his mortgage is going to be the exact same that it is now because his interest rate now is 5.25%. So it's not beneficial for him to sell the property. So needless to say, I said, this isn't going to work. It's not going to accomplish what you want to accomplish. Unfortunately. So we didn't do the listing. So these are things that we have to keep in mind as we're talking to people. Down payment, the balance of the down payment will be paid on or before the settlement date by a certified or cashier's check or wired fund. An assignment of funds is not to be used without prior written consent of the seller. Anybody got any questions about that one?
Do you want to check your chat box? They're talking about Michelle Reebok with cross country. We could have her come in.
Okay.
Yeah.
Yeah, she touched on it a little bit. last Thursday.
Good.
Okay. Settlement. The seller and the purchaser will make full settlement in accordance with the terms of this contract on or with mutual consent before. That means on this date or before, you can go to closing. Except as otherwise provided in this contract, the purchaser selects, buyer gets to choose who their title company is, settlement agent. West Virginia, it's always an attorney. Either party may retain their own legal counsel. If they want to do a split settlement, they can. And the purchaser agrees to contact the settlement agent within 10 days from the date of ratification. So it's the buyer's responsibility to get this contract to the title company or the settlement attorney within 10 days of ratification. Property maintenance and condition. This is a very important one because West Virginia does it a little bit differently. It says, it's property maintenance and condition, except as otherwise specified herein, the seller will deliver the property free and clear of trash and debris, room clean and in substantially the same physical condition to be determined as of. And they give you the choice. Contract date, date of the home inspection, or an other time. Date of closing, could be the date of the walkthrough, could be the date, could just be a date that you want to throw out there. Could be 5 days before closing. But it does state that the seller will have all the utilities in service through settlement or as otherwise agreed. To the purchaser and seller will not hold the broker liable for any breach of this paragraph. So buyer and the seller are not going to hold the broker responsible if it's not room clean and power's been shut off. However, it's not supposed to be. It's supposed to be room clean and power shut off.
What happens if you go to do your like home inspection and the city had turned the water off?
Can't do the home inspection. The seller needs to get the water turned back on for the inspection. Going to need an extension of time to get it done. Okay.
They finished doing an inspection, they just, I don't know, they did it, but they just noted that they couldn't complete it because of that. So I don't know if I go back to Fox and say, can you come back out and see what their fee is now that the water is turned back on?
Yeah, I would, because they need to check the water and see if anything's going on.
Okay, thank you.
So you need to figure out what's the best time frame to put in here. Date of the contract, date of the home inspection, or another date. What's the best one? We have
The
one-
inspection date. Inspection date,
Why the inspection date?
because it's later than the contract date.
See, and sometimes I think it's the contract, because the house tends to be broom swept and in good condition because of all the scheduled walkthroughs. I don't know. That's good. What's the answer?
There is no correct answer. It just depends on what you want.
What do you mean, it's a correct answer?
So I always choose the home inspection date because it gives the buyer another opportunity to really spend more time inside the house.
Mm-hmm.
And if there's a concern, then I can maybe address it with the agent on the other end during that home inspection. And that's why I choose that date. I had one client that wanted me to choose the day before the day before the closing. And it was quite a fiasco to go to closing on the next day. So,
Because I'm sure there was probably a lot of items that could have changed.
yeah, a lot of items because they had moved out. So some of the things that he assumed that he was getting, even though they were not on the items to convey, he just assumed that. So it just was kind of an interesting time. It was just,
So when the home inspector's there, they inspect all the appliances.
right.
So if the appliances convey and they're not marked to be excluded, and they inspect all those items, if those items are gone, there's an issue. So you can put the contract date, but that's not necessarily the best date to put. Putting the inspection date is going to allow for everybody to do what they need to do as far as inspection go. They're gonna inspect the items. You're gonna know if the items were not inspected, you're gonna know that they're not going to remain because they were excluded. So date of the home inspection is always a good date. Now, the purchaser acknowledges, subject to the seller acceptance, that this contract may be contingent upon the home inspection and or the inspections to ascertain the physical condition of the property. If the purchaser desires one or more inspection contingencies, such contingencies must be included in an addendum to this contract, which they do have an addendum to the contract of sale that includes your inspections. And then you're going to mark whether or not the contract is contingent on home inspections, or if the purchaser declines the opportunity to make this contract contingent upon inspection. If the purchaser declines the opportunity to make this contract contingent upon inspection, what does that mean for the purchaser?
If they don't make.
Can you,
Is that what you asked? If
Yeah,
they don't make
it's
it contingent, then they have
correct.
to take it.
That's correct. If it's not contingent on inspections, then the buyer's got to take it. Buyer can also not be given the opportunity to do inspection. And it says that the purchaser acknowledges that the contract and the property, including the electrical, plumbing, existing appliances, heating, air conditioning equipment, and fixtures shall convey in its as-is condition, as the date specified above. That's where that date's important. So if all the appliances were inspected and they all worked, then it's the as-is condition of the date specified. If they didn't work during the inspection, then they're not going to work at closing. If they did work at the inspection date and they don't work the day of closing, there's a problem. Somebody's got to get something fixed. Now, in West Virginia, it's a little bit more difficult than that, because you're gonna have to go to court, and then the court will decide. Seller has to provide access to the property to the agents, the purchaser, the inspectors, the appraiser, and it has to be done within reason to comply with this contract. In addition, the purchaser and the purchaser's representatives have the right to make a final inspection within 5 days prior to settlement and for occupancy. So if they're going to do a pre-settlement occupancy, they can inspect it 5 days before that, unless they agree otherwise. Utilities, you're going to mark down the types of utilities that are here, whether it's public, private, or community. There's a couple places in West Virginia where they do have community well and a community septic. Typically, those people know if it's a community well or septic. If you see that it is a community well or septic, sometimes it's a little bit harder to get like a VA or a USDA loan,
Right, so
because they don't like that there's a community using a well. Most builders in West Virginia know that, and they'll end up putting in, like they did at Honeywood, they'll put in their own public sewer system, but it's not public, or they'll put in their own public water system, but it's not public. So just mark those. Personal property and fixtures. This is an important one, because everybody now has flat screen TVs, so they mount them on the wall. Mounts are not. So the property includes the following personal property and fixtures, if existing, built in: heating and central air conditioning equipment, plumbing and lighting fixtures, sump pump. This is the one that surprised me. The attic. Exhaust fans, storm windows, storm doors, screens, installed wall-to-wall carpeting, window shades, blinds, and window hardware. All surface or wall-mounted electronic components and devices do not convey. So if they have a surround sound system, flat screen TV, all that can be removed. Any component removed requires wall repair and will be corrected by the seller, including paint. If more than one of an item convey, the number of items is noted. See the items conveyed. So where they mentioned the attic, I think what they meant to say was attic exhaust fans instead of just the attic.
I was like, we tried to take it, how do you take it? How do you take it out? Like, because people want to know. Okay.
So somebody on the forms committee is probably going to have to go back and remove the comma after attic. So it's not talking about just the attic. Leased items. Any leased item has to be listed on this section. And leased items can consist of propane tanks, water treatment systems, lawn contracts, security systems, satellite contracts. Something that's not big yet in West Virginia, but it will be. Solar panels are also usually leased. And there has to be an agreement. And the buyer needs to be informed they do not convey unless there's an agreement. And then there's where they write down the list of leased items. Financing application, you got 7 days to apply for your loan. The buyer has 7 days from the contract acceptance date to make a written application for the specified financing and enter any lender required property insurance no later than 7 days after the date of ratification. So they got to search for their homeowner's insurance along with applying for their loan within 7 days of ratification. If they don't do that, contract can be declared null and void by the seller and the buyer would be in default. The default paragraph will tell you what happens if they go into default. The seller agrees to comply with reasonable lender requirements, except as otherwise provided in the lender required repairs paragraph of the applicable financing contingency addendum. During the financing contingency addendum, there's going to be a place to put the amount for lender required repairs, or they will spell out that the seller is responsible for that. Can the seller refuse to do the lender required repairs?
Well, if he signed the addendum, no. The financing addendum. Because he's already agreed to that, I'm assuming, because he signed the financing addendum.
Well, the seller agrees to comply with reasonable lender requirements, except as otherwise provided in the lender required repairs paragraph.
Okay, so that just sounds like baloney to me. What does it mean in English? I'm like, oh my God. Wow. Sorry.
Hey, you got to talk to the lawyer that wrote it.
He's an idiot. Okay, I'm like,
The reason the lawyer wrote it was reasonable is replacing the roof a reasonable lender required repair.
yes, if it's falling in, of course it is. It's for the structure of the home.
No. No,
If you only wrote $500 in the lender required repairs section of the addendum, is it a reasonable lender required request?
it wouldn't be if you wrote in $500. No.
So, well, I usually put around $700 for the termite problem, but I mean, because that's about average is what I've come up with, but
The seller has the right to refuse unreasonable, what they think is an unreasonable lender required repair.
okay, so anything can be unreasonable to someone. I mean, I can say, I don't want to fix the faucet, so I'm not going to fix it. I mean, that's like, you know,
Well, fixing a faucet's a lot different than fixing a roof. I would say that the buyer would probably win that one.
What about adding a stair rail out, like on an exterior?
I'd say that's a reasonable expectation.
well, shouldn't we have a list of what's unreasonable? If they're going to put that in there?
Well, that's for the attorney. That's for the attorneys to figure out, not us.
No. Well, let's make it more complicated. Thank you very much.
You're welcome.
I want to have to meet with the attorney and Trish, because that would be. Can I come?
I want to sit in on it too.
She would tear him up, or her, whoever.
Well, I'm telling you, when I had to talk to an attorney about what does the word new mean,
Mhm.
that's when I knew I did not like attorneys.
Alternate financing, this is new. The reason this is new is because with the market being so hot and crazy, what a lot of buyers agents were doing was they would say that they were going conventional. So that the person would take their offer and then turn around, oh, well, we gotta go USDA now, or we gotta go FHA. Oh, they decided to go VA. That's fine, you can do that. The purchaser may substitute alternative financing and or an alternate lender for specified financing provided. Purchaser is qualified for the alternative financing, and there's no additional expense to the seller, and the settlement date is not delayed. And if the purchaser fails to settle except due to any default by the seller, then the provisions of the default paragraph shall apply. Can't wait to get to that default paragraph.
Yeah.
So if the buyer says he's going conventional, now all of a sudden he's going FHA, and you need an additional 15 days to close, what's that mean? That means you're going to go to the default paragraph. Can you ask for an extension? You can. Default paragraph is probably going to be the better option. Purchaser's representation, the purchaser will or will not occupy the property. You have to let them know. If it's going to be a principal residence, unless specified in a written contingency, neither this contract or the financing is dependent or contingent on the sale and settlement or lease of another property. So that means that this contract, once executed, if they had a house to sell, if you don't have the appropriate addendum in there, this contract is not contingent on a house to sell. They can be denied their loan because they didn't sell their house. They're not going to get their deposit back. Or well, it'll fall under the default paragraph. Let's read that first. The selling company is or is not authorized to disclose to the listing company, the seller, and any lender appropriate financial or credit information statements provided by the selling company by the purchaser. The purchaser acknowledges that the seller is relying upon all of the purchaser's representations, including without limitation, the accuracy of the financial or credit information given to the seller. So what does everybody typically do here? Which one do you guys mark? That they are authorized or if they're not authorized?
Not authorized.
Why?
I remember taking a class with you and you told me that was a better one.
If they're not authorized, they have to continue to reach out to you to get the information. If they are authorized, they can reach out to the lender and find out whatever they want. And they're signing it so they can send this contract into the lender and say, well, we have permission to talk to you about it. We have permission to talk to you about the credit issues, et cetera. So I always make it a practice that they're not authorized, they're still gonna reach out to me. And until somebody tells me differently, that's probably what I'll continue to do.
Well, I kind of think it's more of a common courtesy too, between two agents to discuss information.
Should be.
Uh.
But you can't always discuss things with other agents. Sometimes you get disgusted, but
Well, but I want someone to ask me first before they reach out to the lender.
yeah. Do they have to?
Well, according to this contract, they do. If I've
Oh,
if I've actually selected that, they're supposed to.
is that what it says?
Wait, go back, let me see.
The selling company is or is not authorized to disclose to the listing company, seller, and any lender the appropriate financial or credit information statement provided to the selling company by the purchaser. Purchaser acknowledges that the seller is relying upon all of the purchaser's representations, including without limitation, the accuracy or financial or credit information given to the seller, broker, or the lender by purchaser. Doesn't say they can't contact the lender. They just can't get financial information
So what
from the
else,
lender.
what else would they, well, financial information being, if I were to reach out to the
If you
lender,
reach out to the lender,
I just ask, is everything, are we on track? That's
Yes.
the only thing I ask, because that's the only thing I care about.
right?
Right.
And that's all you need to worry about.
Okay.
If you start getting into situations where it's not, then they're probably not going to answer your
They
questions
should.
and going to make it a little bit more difficult for you to get information.
If you're trying to find out anything else, you got a different problem.
So yeah, the listing agent can reach out to the lender, but they can only ask basic questions. How's the loan going? Lender could even reach out to the listing agent if they want to. I've had lenders do that
Well,
and say, hey, we have a strong borrower. He's
Mhm.
really good to go.
I've had that one very much this recently. Mhm.
Absolutely, I did too.
Mhm.
But
And then we later found out that they had to pay off 2 car loans in which to get to closing that we had no idea about. Mhm.
So
They
he
delayed
did-
our closing twice.
So he did not provide very accurate information.
No.
Not to give you that information anyway. So yeah, they can still reach, a listing agent can still reach out. They just can't provide any information. The lender's not even going to provide you with a lot of information on that's on their credit. They may give you a little bit just so you kind of know what's going on, to try and figure out how to work through it, but they're not going to give you a whole lot because they can't discuss it.
Right.
Damage or loss, the risk of damage, loss to the property by fire, act of God, or other casualty remains with the seller until the date of closing. That's when they actually execute and deliver the deed. So if the house burns down the day before closing,
Bad luck
that's really
for the
bad
buyer.
for the buyer, because he's got no place to move to.
Mhm.
And the seller's gonna have to have the house rebuilt through his homeowner's insurance. That just happened recently here in Hagerstown. Title. This big, long paragraph about title. says that settlement may be delayed for up to 10 business days to obtain a title report and survey after the contract at the option of the seller may be terminated and the deposit will be refunded in full to the purchaser according to the terms of the deposit paragraph. So if the title report or a survey are required, they'll be ordered promptly. And if they can't provide free and clear title, the contract can be delayed automatically for 10 business days to obtain that. Will you need an extension of time written separately?
I don't think you need one, but I go ahead and do it anyway.
That's correct.
So,
That's called
That's great.
CIA. According to the contract, you don't need one, if, as long as it is a title defect or a survey defect that is needing to be corrected. If it's a big issue, it's gonna take longer than 10 days anyway. And if it's gonna take longer than 10 days, the seller can terminate the contract, but he has to give the deposit back. Can't keep it. Be simple title to the property and everything he conveys with it will be sold free of liens, except for any loans assumed by the purchaser. So if there's an assumption, then that would be assumed, and that would not be released. So that way they can still foreclose on the property. Titles to be good and marketable and insurable by a licensed title insurance company with no additional risk premium. And the title may be subject to commonly acceptable easements, covenants, conditions, and restrictions of record. And where do you find those? Correct. You usually find those in the deed. And if there's separate restrictions for developments, they'll be in there along with HOA. Are you to provide those documents to the buyer?
If they come from the attorney.
If they're listed in the pre-list, in the documents, you can, but
Oh,
shouldn't
no,
they?
you cannot.
Mm-mm.
No, you
Mm-mm.
cannot.
So if they're listed there, like all in the file for the,
Do you know if those are the most up-to-date covenants and restrictions and HOA docs?
you don't know, but isn't that the?
Okay,
job
if you don't know, then you're not giving them.
Oh, so separate the file out when you download everything. Don't just click send those documents, take those out and then let title handle.
You let the title attorney provide the most recent copy of covenants, restrictions, easements, and HOA documents.
Mhm.
Because if you hand off the documents and every other page was missed,
Thanks, Lenny.
Dang,
or look,
See,
I'm
speaking-
not calling anybody, I'm not calling names.
Well, it actually happened to me. So
Just
yeah,
use the samples. If you miss every other page,
it did. Mhm.
or they were the ones that were initially used and they quit using those about 10 years ago and they have a whole new one, you're responsible. You as the agent, because you gave them to them, are responsible.
Lenny,
Yes,
what I've been doing now is I send a letter. I send an email to the attorney's office with my client's email address,
yep,
asking them to forward all the covenants, restrictions, and easements, or any kind of important information to the buyer directly. And a
That's
lot of times
correct.
I'm CC'd on it as well, but it's coming from the attorney's office.
that's correct.
What about any type of FEMA documents like flood zone type stuff? Would that
That's their responsibility. for
That is
them to-
their responsibility to disclose.
The buyer's responsibility, and they can go to the building, they can go to the, I forget the name of the,
It's actually the seller's responsibility to disclose whether or not they have flood insurance.
Yeah, they did, but now this is new to me. Like I've always just sent what was provided and I've just always had them initial it with the understanding that the title company is going to give the most updated documents. But now, well, that's.
Yeah, but you have a situation, so the situation that we had come up is the person bought a property.
Mhm.
He wanted to be able to hunt on that property. Well,
Mhm.
in the 12 pages that he received, there was nothing that said he couldn't hunt. He read them, agreed to it, and moved in. Well, it was on one of the missing pages that you can't hunt. So had he known that ahead of time, he would not have bought that property.
Okay, that makes sense. I'll remove those on.
Okay, okay, so, title may be subject to commonly accepted easements, covenants, conditions, restrictions, records. Otherwise, the purchaser may declare this contract void unless the defects are of such character that they may be remedied within 30 days beyond the settlement date. So I'd say the biggest situation that I have found so far has been a builder in Morgan County that went up to a piece of ground. He subdivided it, built the house here, start the house right here. And he started it directly on the property line of two properties. So half of the house was on the property, half the house was on the neighbor's property. All the houses were like that the whole way down. Because he did the distances. He didn't do the survey, but he did the distance. That took a little less than 30 days to remedy because he was also a member of the zoning committee. He was also a developer. He was also on the planning commission, and he was also a clerk in the courthouse.
Wow.
Wow, no conflict there. Conflict there.
So-
Where's my attorney now? Mhm.
So he was able to get the whole thing remedied in a matter of, I think it was like 12 or 13 days. But you have, it could take up to 30 days beyond settlement. In case action is required to perfect the title, such action must be taken promptly by the seller at the seller's expense. Seller did have to do it at their expense. The broker is hereby expressly released from liability for damages by reason of any defect in title. The seller will convey the property by general warranty deed in West Virginia. That's what they all are. Seller will sign such affidavits, lien waivers, tax certifications, and other documents as may be required by the lender, title insurance company, settlement agent, or the government authority, and authorize the settlement agent to obtain payoff or assumption information from any existing lenders. The manner of taking title may have significant legal and tax consequences. Purchaser is advised to seek the appropriate professional advice concerning the manner of taking title. So the buyer should seek competent legal advice on what it means to take title to this property. Unless otherwise agreed to in writing, the seller will pay any special assessments and will comply with all orders or notices of violations of any county or local authority, condo unit owners association, homeowners, or property owners association, or actions of any court on account, therefore, against or affecting the property on the settlement date. So if they are going to continue on with closing, because there could be a cloud on title, they can do so as long as it's not going to take 30 days, longer than 30 days to clear it up. And if the buyer is willing to do that, he should seek competent legal advice before doing so. Because keep in mind, the title company does not represent the buyer, nor do they represent the seller. They represent the interest of the transaction only. Possession date, unless otherwise agreed to in writing between the seller and the purchaser, seller will give possession of the property at settlement, including delivery of keys, if any. If the seller fails to do so and occupies the property beyond settlement, the seller will be a tenant at sufferance of purchaser and hereby expressly waives all notice to quit as provided by law. Purchaser will have the right to proceed by any legal means available to obtain possession of the property, and the seller will pay any damages and costs incurred by the purchaser, including reasonable attorney's fees. So what does that mean? That means the day of closing, the seller better be moved out. If the
Even though
seller,
some of them think that they have a couple days after closing to get out.
if the seller is not out on the day of closing, my rule of thumb is you do not close. That you file an extension to close in a few more days. Because if you close, your buyer's not going to be happy. Because now if the seller decides he doesn't want to move out, or he's going to take his time to move out, he can kick him out, but he still has to use the legal remedy to kick him out. And that's going to be at the buyer's expense. Fees. Fees for the preparation of the deed at the portion of the settlement agent's fees billed to the seller, cost of releasing existing encumbrances, seller's legal fees, all that. Buyer's responsible for their portion of it, the seller's responsible for their portion of it, unless it was agreed to otherwise. That's typically under the seller's assistance, where the seller agrees to pay up to a certain amount. And they will be reasonable fees and customary for the jurisdiction in which the property is located. And to figure out transfer tax in West Virginia, it's $7.70 per 1,000 plus $20. Broker's fee. At the time this agreement is made, the broker's fee is due. However, as set forth in the listing, the amount that's set forth in the listing agreement is going to be paid at settlement. And that's what everybody agrees to. But you are due once this is signed. You have done your job. Does everybody enforce that? Nope, not a person around that I know of. But we can. Probably spend a lot of time in court and get nothing. They're just gonna kind of, what? You expect me, what? It didn't close. It doesn't say it has to close, it says I did my job. Adjustments. Adjustments are always made. They are the property taxes, sewer fees, if there's rent, if there's a front foot fee, condo association, homeowners association, those are all prorated. So the seller will be responsible for them up to the day of closing, and the buyer will be responsible for them from the day of closing. The one thing that I don't see on there, oh, it might be in the next paragraph. Taxes, general and special, are to be adjusted according to the certificates of taxes issued by the settlement, whether assessments have been levied or not, will be paid by the seller or allowance made at settlement. If the loan is assumed, interest will be adjusted to the settlement date, and the purchaser will reimburse the seller for existing escrow accounts. The thing that I don't see on there is the ambulance and fire tax. West Virginia has an ambulance and fire tax that will also be prorated. Attorney's fees, this basically says that if any party breaches this agreement, they're all going to have to pay their own attorney's fees. Remember, seek competent legal advice to enforce their rights under the contract. So if the buyer feels the seller is not doing what they're supposed to be doing, they should seek competent legal advice. If the seller doesn't think that the buyer is doing what they're supposed to be doing, the seller should seek competent legal advice. Everybody's going to go to court, and somebody's going to be made to pay the legal fees of the prevailing party. In the event a dispute arises resulting in the broker or their licensed agent of the broker being made a party to any litigation by the purchaser or by the seller, the parties agree that the party who brought the broker into litigation shall indemnify the broker for all of its reasonable legal expenses incurred, unless the litigation results in a judgment against the broker. So if you did wrong, and they find you did wrong, you're going to pay the legal fees. Otherwise, if the seller takes the buyer to court due to no fault of either of the brokers and the seller wins, they have to pay our attorney's fee. Performance, delivery of the required funds and executed documents to the settlement agent will constitute sufficient tender of performance. Funds from this transaction settlement may be used to pay off any existing liens and encumbrances, including interest as required by the lender. Default. Oh, here's the default paragraph we've been waiting on. If the purchaser fails to complete settlement for any reason other than default by the seller, at the option of the seller, the deposit may be forfeited as liquidated damages, not as a penalty, in which event the purchaser will be relieved from further liability to the seller. If the seller does not elect to accept the deposit as liquidated damages, the deposit may not be the limit of purchaser's liability in the event of a default. If the deposit is forfeited, or if there is an award of damages by a court or a compromise agreement between the seller and the purchaser, the broker may accept and seller agrees to pay the broker 1/2 of the deposit in lieu of the broker's fee, provided the broker's share of any forfeited deposit will not exceed the amount due under the listing agreement. If the seller fails to perform or comply with any of the terms and conditions of this contract, or fails to complete settlement for any reason other than default by the purchaser will have the right to pursue all legal or equitable remedies, including specific performance and or damages. If either seller or purchaser refuse to execute a release of deposit when requested to do so in writing, and a court finds that such party should have executed the release, the party who refused to execute the release will pay the expenses, including without limitation, reasonable attorney's fees incurred by the other party in the litigation. Seller and purchaser agree that no escrow agent will have any liability to any party on account of disbursement of the deposit or on account of failure to disperse the deposit, except only in the event of the escrow agent's gross negligence or willful misconduct. The parties further agree that the escrow agent will not be liable for the failure of any depository in which the deposit is placed, and that the seller and purchaser each will indemnify, defend, and save harmless the escrow agent from any loss or expense rising out of the holding, disbursement, or failure to disperse the deposit, except in the case of the escrow agent's gross negligence or willful misconduct. If either the purchaser or seller is in default, then in addition to all other damages, the defaulting party will immediately pay the costs incurred for the title, examination, appraisal, survey, and the broker's fee in full. So, does everybody gather what those three paragraphs are saying? Nobody got any questions? Did we lose everybody?
I muted myself, but I'm here.
I'm here. Sorry, changing a diaper.
I'm here.
All right. So nobody has questions about that. That's good.
What are common misconceptions you find? That's-
Well, agents seem to think that the seller is immediately entitled to the deposit, or the other agent believes that the buyer is entitled to the deposit. What this paragraph says is if both parties agree on where the deposit is going, that is the limit of what can be done. If neither agree, then somebody needs to seek competent legal advice and use an attorney to go after that deposit. Have it released to whoever the party thinks it should go to if it's not agreed upon.
So Lenny,
And wait a
Just-
minute, wait a
oh,
minute.
sorry.
And that person that's going to take it to court will be responsible and immediately pay the cost incurred to the title company, the appraiser, the survey, and the broker's fees involved. Okay, go ahead, Trish.
I was just saying, can you give us an example? Like just something that happened to within our office or wherever that you can, like, for example, my couple that bought the house, had a house for sale, and the gentleman didn't show up for closing. And then they had to take him to court to get the earnest money, but he would not comply. And he went to Haiti. So I don't even know what happened to the earnest money. I have no idea.
And they did what they were supposed to do. They took him to court. They probably found in their favor. And he's probably, if he's out of the country, it's hard to say what happened, but he's responsible for all those fees. How they'll get it, I don't know.
Well, then I would think that our office would get some of that,
Well, we're supposed to get our fee, yeah.
which we're not going to get because the seller never sold the house.
Yeah, but the buyer is in default. And
Yes.
they would not agree to release the deposit, so the seller took the buyer to court. They were probably given a judgment for that amount, along with the broker's fees and the title fees and appraisal and all that, so that those people could be paid. And there's probably just a judgment laying out there for that person. If he left the country, he don't care. He only has to worry about it if he ever has to come back. In West Virginia, they still have debtor's jail.
Debtor's jail?
Yeah.
What?
Tell us more.
West Virginia has debtor's jail. If you owe a debt and you do not pay it, they will arrest you and put you in jail for it. So like if you take you have a check and it bounces, you don't make good on it, you're going to jail in West Virginia.
All right.
Other disclosures. Now, the seller probably has more at risk under the default, because if the seller defaults, the buyer can sue him for specific performance, kick him out of his property. So, and you'll see this happen if the seller needed to sell their property, but didn't have a house to sell contingency and a house to settlement contingency, and they're going to closing, and well, I was supposed to be able to sell my house to get my loan. I can't get my loan, so it was denied. Nope, you didn't put a house to sell contingency in there. It doesn't work that way. Remember, this contract is not contingent on the sale, settlement, or lease of another property. So,
I had an incident that happened to me about that. My buyers had to sell their home and they sold it to their daughter. Okay. Even though they hadn't gone to closing when we were filling out the thing, they told me they had sold the home. So I didn't put a home sale contingency because she said she sold the home. And then later I was like, you mean you didn't sell it? So I had to go back to the agent, and lucky enough, it was just fine, but it could have been a real fiasco.
yeah,
So, just because they think they've sold it does not mean they've actually, did they go to the attorney's office and is the deed out of your name is what I have to ask from now on. It's not, did you sell your home? I can't ask that anymore after that incident.
see, these are all learning experiences that we have.
Mhm.
So other disclosures, the purchaser and seller should carefully read this contract to be sure that the terms accurately express their respective understanding as to their intentions and agreement. The broker can counsel on real estate matters. That's it. What is a real estate matter?
Broker can counsel on real estate matters. In buying or selling a home.
But in buying and selling a home, what is a real estate matter?
Real property.
Filling in the blanks.
Mhm.
That's it.
Oh, okay.
Because you're not legal counsel. If they want legal counsel, they should seek it.
Mhm.
You're also not a surveyor. You're also not a home inspector. You're also
Not an
not a
accountant.
title attorney. You're not an accountant. You're not an insurance agent anymore.
I am. I am. I still have my license.
Oh, do you?
So I can tell people that I still have an insurance license.
Okay, good. I used to have my HVAC license, and I used to tell people I still have my HVAC license. I don't do that anymore. Because you get calls in the middle of the night, hey, I don't have any heat. Can you come fix it? Nope. So the following provisions of the paragraph disclose some matters which the parties may investigate further. These disclosures are not intended to create a contingency, and any contingency must be specified by adding appropriate terms to this contract. The parties acknowledge the following disclosures: property condition, various inspection services and home warranty insurance programs are available. Brokers not advising the parties as to certain other issues, including but not limited to. It goes through the whole list of different items. We're not going to go through all those. Just remember, you don't know anything about any of those things. Unless flood hazard, you'll probably know because the lender will point it out. If there's restrictions, that'll be in the deed. You give a copy of the deed to the buyer. You can probably do that. I wouldn't provide covenants and restrictions and things like that. If you are going to provide a deed, I would make sure it's the entire deed. Legal requirements, all contracts for the sale of real property must be in writing to be enforceable. So if it's not in writing, it doesn't exist upon ratification and delivery. This contract becomes a legally binding agreement. Any changes to the contract must be made in writing for such changes to be enforceable. So you can't just verbally agree that the buyer and seller are gonna work together and paint the house before closing. Gotta be in writing. When do you have delivery?
Once everything has been signed.
Well, if everything's been signed and you don't have a copy of it. but the
No, it has to
listing-
be, it has to go out to everybody as well, all
That's-
parties involved,
That's
buyer, seller, listing agent, buyer's agent.
correct. And do you have to provide a copy of it to your client?
Yes,
Yeah,
My gosh, that better be one of the first things you do as soon as you get it.
yes. And mine, I just send it to them electronically, but they have to sign for it. So that I know that they received it and opened it.
Yeah, because there are people that call the office here and say, I never received a copy of it. Financing, the mortgage rates and associated charges vary with financial institutions in the marketplace. Purchaser has the opportunity to select their own lender. And they have the right to negotiate terms and conditions of the financing. Financing may require a substantial lump sum balloon payments on the due dates, and the purchaser has not relied upon any representation regarding the future availability of mortgage money or interest rates for the refinance of any such lump sum payment. Purchaser and seller acknowledge that the broker is being retained solely as a real estate agent and not as an attorney, tax advisor, lender, appraiser, surveyor, structural engineer, mold or air quality expert, home inspector, or other professional service provider. The broker may from time to time engage in the general issue insurance, title insurance, mortgage loan, real estate settlement, home warranty, and other real estate related businesses and services. Therefore, in addition to the broker's fee specified herein, the broker may receive compensation related to other services provided in the course of this transaction pursuant to the terms of a separate agreement and disclosure. So if you're using Keller Mortgage, because Keller Mortgage is affiliated with Keller Williams, the person is going to be paying Keller Mortgage monies, and we have to disclose that because we have an affiliated business arrangement with them.
Is there a form that we use with that?
It is on the Keller Mortgage site for you to download.
Okay,
And I think we put it in the KWPR document.
and DocuSign?
Yeah.
Okay,
Property tax bill could substantially increase the following settlement. For more information on property taxes, contact the appropriate taxing authority in the jurisdiction where the property is located. So you're not telling them about the property taxes. Somebody else is. West Virginia has a 3-tier property tax bill. Just be aware of that.
it has a 3.
3-tier. If the property was ever used as a commercial property, if the property was ever used as a rental property, if the property was used as a primary residence. And if you have a buyer that's purchasing a property that was used as a rental unit, their taxes are going to be higher the first year that they live in there until their tax bill comes in their name and they're recognized as a owner occupant. If I remember correctly, you should have your buyer contact the tax office the following year because they're not automatically going to do that. Property insurance, they have to obtain property insurance. It's a requirement of the lender in order to secure financing, and insurance rates are different depending on where it's located and types of animals and stuff like that. Make sure they consult with an insurance company. You can use Keller Covered to get them quotes and talk to insurance agents. I've used Keller Covered a couple times with folks and found that they got some really good rates for their buyers. Just had one, they were paying a little over $900 a year. They were able to get the same type of coverage And they actually added sewer backup, $300 less a year.
No.
Assignability, the contract cannot be assigned without the written consent of the purchaser and seller. If the purchaser and seller agrees in writing to an assignment of this contract, the original parties to this contract remain obligated under the settlement until settlement. And then it gives you a list of definitions. Appraiser means a written appraised value. Days means the calendar days unless otherwise specified. All reference to time of day shall refer to time of day in Eastern Time Zone. For the purposes of computing time periods, the first day will be the day following delivery, and the time period will end at 9 p.m. on the day specified. Settlement date falls on a Saturday, Sunday, or legal holiday, and the settlement will be on the prior business day. Date of ratification means that the date of the final acceptance in writing by the purchaser and seller of all terms of this contract, not the date of the expiration or removal of any contingency. For delivery and notices, definitions, see the jurisdictional addendum. Specific financing means the loan type and amounts, if any, specified in the price and financing paragraph. The masculine includes the feminine and the singular includes the plural. Okay. Possession date, see the possession date paragraph. Legal expenses means attorney's fees, court costs, litigation expenses, if any, including but not limited to expert witnesses, fees, and court reporter fees. Miscellaneous. This contract may be signed in one or more counterparts, each of which is deemed to be an original and all of which together constitute one and the same instrument. Documents obtained to be a facsimile machines will also be considered as original. Typewritten or handwritten provisions included in this contract will control all pre-printed provisions that are in conflict. Void the contract if the contract becomes void and of no further force and effect without default by either party. Both parties will immediately execute a release directing that the deposit be refunded in full to the purchaser according to the terms of the deposit. Whether or not there's a home warranty, the home warranty policy, who it's going to be paid for, and the cost cannot exceed, and the warranty provider to be. This is the entire agreement. It is binding upon all parties and each of their respective heirs, executors, administrators, successors, and permitted assigns. Provisions not satisfied at settlement will survive the delivery of the deed and will not be merged here therein. This contract, unless amended in writing, contains an entire agreement of the parties. And the parties will not be bound by any terms, conditions, oral statements, warranties, or representations not herein contained. So if it's not in writing, it doesn't exist. The interpretation of this contract will be governed by the laws of the jurisdiction where the property is located, which is West Virginia. Which brings up the West Virginia jurisdictional addendum. Date of ratification, make sure that's in there. Make sure both buyer and seller have signed it. This information should be completed for my information if I need to go into and look at and help out for any reason. Okay. Any questions with the contract?
I'm good.
So we got about 30 minutes. Let's go to the jurisdictional addendum. And you'll notice that that contract was revised. Pull that up. You always want to look at the bottom of the contracts to see the last revision date. If you're pulling it from the Eastern Panhandle, it will be the correct contract. If you're not pulling it from the Eastern Panhandle, and you saved a template or whatever, you're not pulling the correct document. This contract was updated January 2022. It's in the bottom left corner. And yes, there's still a lot of people that are not using the 2022 contract. Let me find the jurisdictional addenda. Now, in West Virginia, do you technically need a buyer agency agreement?
Okay. You said technically.
According to your
That's a
broker,
trick
you do need a buyer agency agreement. However, under West Virginia law, if you are working with a buyer, you are a presumed buyer agent, and you don't have to have the buyer agency agreement in writing. But as your broker, I require one.
Do you require one for all three?
Yes. Use Pennsylvania and Maryland, they're required. Oh, there we go. All right, this is the West Virginia jurisdictional addendum. This is being pulled directly from EPBR. And you must use this in conjunction with the contract of sale. So this addendum is made on the date of the contract between, and I don't know why they do this, but if you read this, it says this addendum is made on blank to a sales contract dated on blank between the buyer and the seller for the purchase and sale of the property. Any terms, conditions, or agreements in the jurisdictional addendum which are in conflict with the sales contract shall be interpreted to supersede and amend the sales contract. Okay? So the jurisdictional addendum supersedes the contract of sale
Grammar and spelling
in
are
a
important,
certain
but
spot.
if you need to write essay,
So delivery methods may include hand carried, sent by professional courier, by United States mail, by fax, or email. Okay? So delivery is deemed to have occurred on the day delivered by hand, or delivered by a professional courier, or delivered by the United States mail, return receipt requested, or acknowledged in writing by the recipient if any other method is used. So it must be signed for in some manner that they received it if you're going to fax it or email it. That's what it says. And that's for both the buyer and the seller. So if you're emailing it, yes, you do have to put the buyer and seller's email address. Nobody likes to do that. But they'll put their own email address. Listing agent will put their email address. The buyer's agent will put their email address. Or you can fax it. And then you're going to put down who the listing company is, and all copies and addendum and amendments and notices required by the contract will also be provided to brokers at the following: fax, mailing address, email address. Notice it says at the following address, email address. So up here, the seller supposed to be the seller's email address. Supposed to be the buyer's email address. the listing company agent's email address and the selling company's email address. That's what it says, right?
Okay, I don't think I ever put the buyer or seller's email address. First of all, we don't have the seller's email
Well, I
address.
put my buyers,
Nope.
on there, but the listing agent usually doesn't put anything back. So I do put my,
I
Nobody
don't.
does, but it is required.
Calling
You're not
you
supposed to
nobody.
leave anything blank.
I put it, they just never put the listing side down.
Well, can we put in there, if depending on which side we're working on, provided by the buyer agent, provided by the listing agent?
Well, okay, so let's talk about this for a minute, so everybody understands. So the buyer goes on a Caribbean cruise. He's gonna be gone for the next 14 days. You put the buyer agent's email address here, and you put the buyer agent's email address here. Buyer's gone, he's not gonna be back for 14 days. When did the buyer receive delivery? Don't hear anything.
I don't know. When did he? How would we know? Is that what you want to hear?
Well, if the buyer's email address is here,
Well, wait a minute, question.
and
If
the
they
buyer's email
signed it,
address is here, when did the buyer receive delivery?
At the time you sent it?
Did the buyer receive it?
We don't know. We know we sent it. We don't know when the buyer received it. I hate when you do this part. Oh my gosh.
So the buyer went on a cruise.
Uh-huh.
Does the buyer have access to his email?
If he paid that extra premium, yeah, which I would if I'm buying a house, but I guess we don't know that either. So no, I'm guessing you want us to say no because they're on a cruise in the middle of the ocean.
So if the buyer's agent email address here, and the listing agent's email address is here, and you both received a signed copy of it, you're acknowledging, because you received that email on their behalf, that they have received the contract of sale. So now they're on a 14-day cruise. They have 7 days to apply for their loan. They have 10 days to do their inspections. 10 days to hire the title company. And they're not gonna be back for 14 days and didn't even know they went under contract.
well, most of that is going to be done with their lender.
What just happened?
That's contract void.
Contract's voidable. You may have just lost your buyer a lot of money. May have just cost the seller a lot of money. Don't know.
Only, wouldn't you have only cost the money if you did the shall or shall not constitute delivery? Oh, sorry. I like to know what's going to cost.
Who's
me.
teaching this class?
Sorry.
So somebody let the cat out of the bag early. You do need to put the seller's email address and the buyer's email address. Okay? Unless the next sentence says, any delivery to the broker representing either the principal shall or shall not constitute delivery. You're going to say shall not constitute delivery. You want to make sure that it's definitely in the appropriate person's hands. So if they're on that 14-day cruise, you can let the listing agent know oh my gosh, they went on a 14-day cruise. I'm so glad we got the contract, but I'm not gonna be able to let them know until they get back. In today's market, that's gonna be kind of a big problem. To make sure that if they're going on a 14-day cruise, or they're going somewhere, or they're going out of the country, make sure they know that they're gonna need to get their email. Because you don't wanna hold up anything. Because if those timeframes are important. No party to this contract will refuse delivery in order to delay or extend any deadline established in the contract. So for that 14-day cruise, on the 14-day cruise, it doesn't, you can't delay the delivery. So if they have to delay the delivery, they can actually, the seller can declare the contract on board. Notice means unilateral communication from one party to the other. All notices required under the contract will be in writing and will be effective as of delivery for the purposes of computing time period. First day will be the day following delivery. The time period will end at 9 p.m. on the day specified. Written acknowledgement of the receipt of the notice is courtesy, but is not a requirement. So what Trish does is a courtesy, not a requirement. Because remember, it does say in the contract of sale, it's required for them to sign, but the jurisdictional supersedes. The deposit, the EMD is in hand, or it will be received within 3 days of ratification, and shall be placed in a trust fund of the listing or the selling broker or the attorney after contract acceptance to conform with the laws and regulations of the appropriate jurisdiction, and or if VA financing applies or as required by Title 38 of the U.S. Code. It's not just West Virginia Code, this is Title 38 of the U.S. Code, especially the VA. Deposit will be held in escrow until credited toward the sale price at settlement. All parties have agreed in writing to its disposition, or a court of competent jurisdiction orders the disbursement, and all appeal periods have expired, or disposed of in any other manner authorized by the laws and regulations of the appropriate jurisdiction. Forms, if ratified and attached, are made a part of this contract. So if any of those forms are attached and made a part of the contract, you will put those. If there's any additionals, they leave you space to write those other addendums. Privacy Act, the seller and purchaser authorize their respective attorneys and settlement agent to furnish to the listing broker and the selling broker copies of the final HUD. And this permission shall also include the ALTA statement. West Virginia withholding for sale of real property by non-residents. This is an important one if they are a non-resident of West Virginia. In connection with the sale of a non-resident's property, West Virginia requires a settlement attorney to withhold funds from the net proceeds. A non-resident income tax return may be required in order to report the sale and determine the total tax due or to be refunded. It's recommended that the sellers contact their accountant and or attorney to determine the tax implications and filing procedures. The West Virginia State Tax Department can be contacted at that telephone number, which you are not going to call. You're going to let the buyer call or the seller for further information. A copy of the code may be obtained at the following website. The website for the seller to go to and find out what their tax might be. Additional fees. Transfer tax shall be paid by the seller. Any HOA costs, including but not limited to transfer fees, shall be paid by the seller. And all normal annual HOA fees shall be prorated. So if they If the HOA charges a fee to receive the documents, the seller has to pay for those. Nothing in this contract shall preclude arbitration under the code of ethics and standards of practice of the National Association of Realtors. Time is of the essence to all terms of this contract. Means many different things to many people, but should all mean the same. The expiration of the offer. This is where the time is of the essence comes into play. You put the expiration of the offer. They've got to respond by then. If they don't respond by then, you can say, no, null and void. Avoid wire fraud. You want to let your buyers and sellers know that they need to avoid wire fraud, that if they're going to be getting a wire, doing something by wire, make sure that they're actually talking to the person that is in charge of that wire. Don't listen to an email, don't listen to anything, call the person directly to get that information. It is the purchaser's due diligence to state that with exception of any written warranties which may exist, they have not relied on any statements made by the seller, the real estate agent, or the broker who may be involved in this transaction. Fitness of the real estate and its improvements for the purpose for which it is being purchased, structural integrity of any of all the improvements upon the real estate, and absence of defects in real estate and or improvements. The buyer's responsibility to do their due diligence. Yes, it is West Virginia law that if a seller is selling his property, he must disclose a material fact that would affect the condition or the value of the property. He has up until 5 days before closing to do so.
What? Not when he's filling out the disclosure.
You will find in West Virginia, there are some agents that don't use the voluntary disclosure because they say it's not mandatory. The voluntary disclosure form is not mandatory. But the disclaimer is if there is a material fact that the seller knows about that will affect the condition or the value of the property.
Okay, I have a question, Lenny.
Go ahead.
So say they wait until 5 days before closing and give you information that affects the condition of the house or the property value. Is that a reason for your buyer to walk?
Can be.
Okay.
They should be able to walk and retain that EMD, right?
They can.
How often have you seen that happen?
You typically see this more down in Mineral County because Eastern Panhandle, most of the agents in the Eastern Panhandle use it. I think there's one that doesn't, Trish?
Right. Doesn't use it. Kind of makes you suspicious every time you go show his property, or at least makes me suspicious.
Yeah.
Mm.
But they are supposed to be filling out the disclaimer, and I've brought that to his attention.
And he's a know-it-all.
Oh,
And
fun.
if he still continues to not, then we'll just have to let him know. Because it is West Virginia law. Purchaser hereby expressly states and acknowledges that they've received a copy of the seller's voluntary property condition disclosure disclaimer statement if provided.
Why do they call it voluntary if they're supposed to do it?
Because the disclosure is voluntary. There's nothing in West Virginia law that says you have to provide a written. West Virginia law just says that you have to provide within 5 days of closing a material fact that will affect the value of the property. Which, quite frankly, I think West Virginia needs to get on board and just require a disclosure disclaimer statement. It's already the law. Now come up with a form to do it. But each board of realtors in West Virginia all have their own documents. Purchasers should exercise the due diligence obligation with respect to the information on sex offenders and crime. The buyer's responsibility to do that. They can go to that website or that telephone number. The purchaser should exercise due diligence and obligations with respect to information on school systems. You're not supposed to be talking about schools. Purchaser has a due diligence obligation to obtain a copy of any covenants and restrictions on use of the property. Purchaser, this information can be obtained from the settlement agent, the homeowners and or property owners association, or the courthouse. The courthouse will have the most up to date. Is the agent supposed to go to the courthouse and get it for him? No. The purchaser. The purchaser acknowledges it is difficult to determine the amount of real estate taxes for the upcoming year, especially if the property has been rented, vacant, or is new construction. If the property was not owner occupied on July 1, the taxes could be more than double for the upcoming calendar year. Tax bill is mailed in late July, approximately 1 year after the assessment, and is the tax bill for the current calendar year. Payment liability for increases in the tax levies or classification changes is that of the purchaser. If they've been there for a year, they need to make sure that the property taxes are for them. Purchasers should also exercise due diligence with respect to the information regarding but not limited to property and surrounding land use and zoning, community development, covenants recorded in land records, home warranties, historic districts and properties, road upgrades, rerouting, stormwater management, flood zones, mold, wastewater system, solar panels, conservation areas, tax districts, insurance costs, airport upgrades and noise, title insurance, occupancy permits, and utility easements. So the buyer is responsible to find all that information out. You're not responsible to find it out for them. You can help direct them where they might be able to find that information.
Lenny, I actually, when I do my buyer's presentation, I have them read that out loud to me. Because I had a client one time say to me, made a threat to me that I should have made it more, I should have been, how did they put it? You should have let me know. You did not tell me exactly what you were talking about. So now I make them read that so there's no misunderstanding.
And that's why this jurisdictional addendum is required in the contract for sale, because it tells the buyer exactly what they're responsible for and how everybody's to accept delivery.
And in this market is when my incident happened, because we're so rushed to do everything. But that's why I make them read that out loud to me now.
And that is it for that. Now we will go over, we've got 10 minutes left, which is good. So
Lenny.
we're going to go over this. Yes.
What about the 522 by? What do we need for that?
Well, there are some agencies in West Virginia, I think Coldwell Banker is one of them. There is a disclosure that states that there's a 522 bypass to be constructed. If the property is affected by that, they're supposed to disclose it to you. Why are they supposed to disclose that to you? Because it affects the value of the property and the condition. That should be in all the listing agents' disclosures. Eastern Panhandle, I don't think has a document for that. Notice of agency relationship. You will have, because it states that you as an agent have the responsibility to both the buyer and seller to disclose agency. So in your contract of sale documents, you have your signed notice of agency by the buyer and seller. And you will have the other agent's notice of agency signed by both buyer and seller. No exception to the rule. When you do a listing, you will have a listing agreement that has a notice of agency in it, signed by only the seller. Is the one, that's the one that you're gonna provide to a buyer to have them sign. That will go in the contract, under contract. Printed name of the agent. If you have a team, each member of the team that is licensed in West Virginia is a licensed agent, will be listed. Now, originally, a year ago, when they came out with the change, they said that if you had a team, you needed to put down all the team members, and if you had an unlicensed assistant, you were supposed to put the unlicensed assistant's name, etc. After further conversations with the real estate commission, it was discovered that was incorrect, because your assistant cannot, unless they are licensed in West Virginia, cannot discuss any portion of the real estate transaction with the buyer or seller. And therefore, they do not have agency with the buyer or seller, so they are not to be listed. So, for example, probably the best example is Mary Lou. Mary would be there, Lori would be there, Michelle would be there, Heidi would be there. And that's it. I think I got it. And then the company name is acting as seller, either the seller's agent or buyer's agent. If it is both the seller and the buyer, you're going to end up doing a separate one, because you cannot check both the seller and buyer until after you actually have dual agency. So once you get, if you go under contract and it is a dual agency situation, you will correct this one. And then everybody will sign from there. And then the agent will sign it on the bottom. Any questions? So does everybody feel better about the contract of sale?
Yes.
Everybody feel better about the jurisdictional addendum?
Better each time.
Yes.
That's a good way to put it, yes.
I mean, every time we do this, I learn something more. Every single time. I don't care how many times I do this class, I still learn more. It's just an endless thing. It's amazing to me.
Well, the day that we stop learning in this industry is the day that we need to retire.
Amen. Amen. Hey, Lenny, I want to talk to you. I want to ask you something real quick about the lead-based paint.
Okay.
All right, because I know we have to go, but I was working with a client right now, with an agent right now who told me that they did not do the lead-based paint, that their broker told them that they were not going to do lead-based paint if the house did not
If the house was not built after 1978, Margie Bartles decided on her own that she would not require the lead-based paint form.
Yes, and so she said, her agent said to me that we're not going to do it because if you fill it out incorrectly, if it's filled out incorrectly, then the agency itself can be fined. So for example, if I I get a lot of them that come when I'm helping with my buyers. Everyone wants me to initial number 4 when they've already said the house was built after 1978. Well, you don't initial number 4, you
That's
only
correct.
sign the bottom.
You only
So-
sign the bottom.
But that's not what what normal people in this industry do. They want you to initial that. So
No, that's because they haven't read the document. They're going probably from another state. They've got to read the document. If they don't read the document,
so
they
she's,
do it incorrectly. I'll send you, if you have your sign in your documents, we will send it to Marty Bartles and let her know that it has been filled out correctly and I require it.
yes, I did do that. And actually the agent did it for me because I told her it was required by my office. And I said, is it possible for me to get a copy of that? And she said, yeah, I'll bring it to you to the closing. So I'm hoping she'll send it to me, but I don't know if she will, but it is with that agency. Yes.
That's why it has to be filled out correctly, because she's correct. And there's so many people that don't read the damn document. It states right on it, if your house was built after 1978, if you have to put the year it was built
Mhm.
and the address, then you complete only section 5 of the left-hand form, which is you just sign it. Because it doesn't apply. Nothing else gets filled out, but yet I see it come through where the listing agent knew what they were supposed to do, didn't do it, and the buyer's agent had the buyer sign it. Wrong.
Well, I have one right now that the house was built in 2001 and the listing agent had everything signed on every single, even where the purchaser is supposed to sign, even though they're not going to sign, filled out for the seller to sign it. And everything was initial. And I was just like, what is this?
And you need to send it back to them and say, this isn't filled out correctly. Read the document.
Yeah.
That's my biggest pet peeve. Agents do not read. And that costs everybody money.
Yeah.
And it's going to create an issue if you have to go to court or if the real estate commission pulls the document and sees it. Because it was not done correctly. Okay, so that's pretty good. We went 2 minutes over. Anybody have any other questions? All right.
Thank you, Lenny.
You're welcome.
Thanks, Lenny.
Everybody have fun.
Thank you.
What's the name of that